This presentation will be looking at the tort of negligence in relation to schools. Specifically, it will be looking at the uncertainty in the law and how this impacts teachers and their liability for negligence. The stakeholder group of this presentation are teachers. Teachers have an established duty of care over their students and are thus liable for injuries caused by negligence. However, it is also relevant that due to vicarious liability, the burden of a negligence claim is instead shifted onto the employer. Therefore, the burden of a teacher's negligence is shifted onto the school. Despite this, teachers are still a relevant stakeholder group in relation to school negligence, as it is their action or lack of action that can result in a case of negligence. A current issue with the negligence tort system in regard to schools is that it places an unfair burden on teachers in relation to their scope of duty. While it is clear that a teacher owes a duty of care during school operating hours, the scope of their duty outside of school hours is not as clear. For instance, there have been cases that have decided that teachers can owe a duty of care before school starts. And there have also been cases that decided that schools can owe a duty of care after school hours. Despite this being the responsibility of the school, it would be the teachers who had to provide for these duties, particularly in the area of providing supervision during these times. As such, it places an unfair burden on teachers, and articles that have looked at this issue have even questioned if it is possible for a teacher to accurately know when they owe a duty of care outside of school hours. If it is unreasonable to expect teachers to know when they owe a duty of care outside of school hours, it would be unfair to then expect them to still adhere to this duty. Ultimately, this places an unfair expectation on teachers where they would have to perform outside of their scope of duty so as to safely avoid being liable for negligence, even in situations in which they might not be liable, purely because the law has failed to provide certainty as to when they would be liable. Not only does this issue impact teachers, but it also impacts other stakeholders of the issue of school negligence, such as the students and the parents of these students. An article by Jeff Delman looked at a similar issue in America. In his article, he looked at how there was uncertainty in the law regarding school negligence, also in the area of specifically uncertainty as to when a teacher is liable. However, in his article, it was from the perspective of the students and parents, and how, because the law was uncertain as to when a teacher would be liable for negligence outside of school hours, this created an issue for parents and students as they would not know when schools would owe a duty of care. There will be two recommendations discussed to resolve this issue. The first will be to introduce law that directly resolves the issue, and the second will be to introduce a no-fault scheme for school-based injuries. These recommendations will be explained in greater detail further into the presentation. The structure of this presentation will consist of an explanation of negligence law and how it applies to teachers, the issue with this current law and its impacts, and suggestions to resolve the issue. For there to be a case of negligence, there are three elements that must be present. The accused party must owe a duty of care to the injured party. The accused party must have breached this duty of care, usually by doing or failing to do something, and that this breach is what caused the harm suffered to the injured party. Duty of care. A duty of care is a responsibility a person has towards another person. For there to be negligence, there must first be an owed duty. A teacher's duty of care to their student is an established duty of care. There are numerous cases acknowledging this duty. For instance, in the case of Ramsey v. Larson, they acknowledge a previous case that had stated that teachers are in a position like that of a parent or a guardian, and so for that reason owe a duty of care to their students. The issue with this duty of care is that it is unclear as to the full scope of when a duty would be owed. While it is clear that there is a duty owed during school hours, and cases have determined that teachers can owe a duty outside of school hours, it is not clear as to an exact point at which a teacher no longer has a duty. In Trustees of the Roman Catholic Church for Dioceses of Bathurst and Kaufman, it was deemed that a duty was owed despite the incident occurring both after school hours and outside of the school premises 300 meters away at a nearby bus stop. This case thus suggests that schools and thus teachers can be liable for negligence not only outside of school hours, but also outside of the school area in general. In the case of Gare and Downs, it was found that a duty of care was owed despite the incident occurring well before school hours. This case is also interesting as it took place in New South Wales, which has a piece of legislation stating that teachers had to be at the school half an hour before school officially commenced. This would suggest that a duty of care would only be owed by that time. However, the incident in Gare and Down occurred before this 30-minute time, and yet a duty was still owed, despite the existence of legislation. So, despite there being legislation, there was still uncertainty towards the scope of a teacher's duty. In the circumstances of these cases, the judgments were fair and reasonable. However, they still create uncertainty in the law, and that impacts teachers. Breach of duty. A breach of duty is a failure to adhere to an owed duty, and often arises when there is a failure to protect against potential risks. However, not every failure to protect against a risk is a breach of duty. For something to be a breach of duty, it must be a failure to protect against risks that are foreseeable, not insignificant, and something that a reasonable person would have taken precautions against. This is defined in the Civil Liability Act under Section 9. An example of a breach of duty that would apply to teachers would be a failure to provide supervision. It is foreseeable that by not supervising students, they might be injured. These injuries could be not insignificant, and this is something a reasonable person would have taken precautions against by supervising them. While supervision alone might not prevent an injury from occurring, it would substantially decrease the risk, and so failure to do so would amount to a failure to protect against potential risks. Causation and harm. This is the final element of the tort of negligence, and it requires that the breach of duty must be able to be connected to the harm suffered. In other words, the breach must have caused the harm suffered. Returning to that previous example for failure to supervise, this could satisfy the element of causation as well. A student injuring themselves while a teacher is not supervising, although it might be the result of the student's own behavior, had the teacher been there, the incident could have been avoided by teacher intervention, and so this links the breach of duty, failure to supervise, to the harm suffered. A good real-world example of a school negligence case that highlights both how the tort of negligence works in relation to teachers, as well as the issue of uncertainty in the law, is the case of Commonwealth and Intervene. In this case, there were some students who had been fooling around with the flagpole inside the school property. On this particular day, the teachers had a meeting, and so there was no one to supervise the students before school. As such, there was no teacher intervention to stop the children from fooling about with the flagpole. It is also relevant that the flagpole was not properly secured to the ground. As a result, the flagpole fell over and struck a kid on the head, injuring them. The courts found in this case that the school had been negligent. They owed a duty of care to the student, they had breached it by their failure to supervise the students to prevent them from participating in dangerous activities, and as a result of this failure, the student had been injured by other students participating in said dangerous activities. Another reason the school was deemed negligent, however, was the failure to properly secure the flagpole. While this case primarily looks at the school's negligence, this still relates to teachers, as they are the ones who are to supervise students, and this case deemed that the school should have provided supervision despite the incident occurring before school had commenced. This case is relevant to the issue of uncertainty in the law, as it demonstrates a situation in which teachers would be liable for negligence outside of school hours. In this particular case, the justification for why the school had a duty of care prior to school hours was because the school had let the students enter the school property, and so they would have a duty of care over any students entering said school. This would apply to teachers in that they can now assume that if schools are letting students into the property, there would be a duty of care regardless of if school had officially commenced. While this judgment does create some certainty towards the issue, it does not entirely resolve the issue. Does a teacher have a duty of care if they were unaware that students were allowed entry to the school? What about if the students had been entering without permission, such as due to the entry being left open? Would it be appropriate for a teacher to not allow students into the school so as to avoid having a duty of care? And if a student was injured as a result of not being let into the school property before school, would the teacher be liable for that? Because the law does not provide answers for such situations, as well as many other situations that could happen, it is instead left up to the teacher to determine if they would have liability in such a situation. Thus, the safest option for a teacher would be to assume that they have a duty of care, even if a court would determine that they would not. As such, teachers would have to perform beyond the scope of their duty of care simply to make sure that they maintain safely within their duty of care. While there is yet to be a standout case in which an unfair judgment has been made regarding the extent to a teacher's duty of care, the lack of certainty could create issues in the future. While the judgment in this case was fair and reasonable, it could have been improved upon by delving further into the issue of when a teacher owes a duty of care outside of school hours, thus allowing for the judgment made to provide better guidance for schools and teachers as to the scope of their duty. But at present, the way these cases are solved are good, yet the lack of certainty in the law is the main issue. A potential solution to this issue could be by way of legislative change, or the introduction of law and statute. Legislative change is the creation of law. By creating law, certainty could also be created through directly stating when a school and its teachers would owe a duty of care to their students. This could be done by having the law state an exact time for when the duty would begin and end, or by creating a list of specific conditions that must be present for a teacher's duty of care to begin. In both situations, this would allow for teachers to know with certainty when they won't be liable for negligence, lessening the burden caused by them not being entirely sure of if they are not liable. An article by Jeff Delman, which looked at uncertainty in the law regarding school negligence in America, had also suggested this as a solution to this issue. In his article, he also looked at the issue from the perspective of the students and parents, and so this solution would also be beneficial for those stakeholders, as it also creates certainty for them as well, as they would then know with certainty as to if a school would owe them a duty of care. An alternative solution would be to introduce a no-fault scheme for school-related injuries suffered by students. A no-fault compensation scheme is a scheme that prioritizes compensating injured individuals. As such, this system does not focus as much on finding out who is at fault and punishing them. However, this system is more costly as the compensation would not be coming from those at fault. This solution also fails to actually address the issue. Instead of resolving the issue of uncertainty, it would merely be lessening the punishment for negligence, and as such lessening the burden caused by not knowing if they would be liable for negligence. While this does lessen the burden on teachers, it does not resolve the issue. In summary of this presentation, the issue currently facing teachers regarding negligence is that the law does not provide teachers with certainty as to when they would owe a duty of care outside school operating hours. This issue puts an unfair burden on teachers as they are not entirely certain as to when they might be liable for negligence. The best solution to this issue would be to create law or statute that creates this certainty. This could be done by having the law specifically state at what time a teacher has a duty, or by stating the exact conditions required for a teacher's duty to exist outside school hours. While the no-fault scheme recommendation does lessen the burden, it does not resolve the issue.